So there's just a few points that I took from Sheena's talk, and in terms of the English legislation, just thought I'd start by briefly addressing, some of the Irish counterparts. I'm afraid it was meant to be my colleague David Kent giving this talk originally. Unfortunately, he had a conflict, so I've drafted it in to replace him on Tuesday. So I didn't have time to put a PowerPoint together or anything like that. I just did my little notes. But hopefully you'll be able to follow along neatly enough. And obviously, if there's any points that you'd like me to elaborate or to repeat, please don't hesitate to ask. So Sheena mentioned in the course of her speech that there's a lacuna in the English legislation in terms of there's no real definition of, what a qualified person or, what the adequate training is supposed to be. And unfortunately, our own legislation, as you know, the Safety, Health and Welfare Work Act 2005, has a similar problem, because Section 2, subsection 2A, refers to a competent person, which is, essentially an instructor who's meant to obviously supervise the relevant areas and advise on how to make them safe and healthy for workers. And I mean, it's a masterpiece of fudge, really, what it says. Because it says, for the purposes of the relevant statutory provisions, a person is deemed to be a competent person where, having regard to the task he or she is required to perform, and taking account of the size or hazards, or both of them, of the undertaking or establishment in which he or she undertakes work, the person possesses sufficient training, experience and knowledge appropriate to the nature of the work to be undertaken. So, what that sufficient training, experience and knowledge appropriate to the nature of the work is to be is left completely blank. And unfortunately, there's been very, very little law on that so far. So it seems it's going to be a matter for the judge in any particular case to decide. So I'm aware that I'm addressing a group of experts here in manual handling and ergonomics. And I'm sure you're all quite familiar already with the regulations, but I'll just go over, I think, the relevant points briefly starting off. And then I can address some of the points that Marek specifically asked me to speak about. So it's the General Application Regulations of 2007 to 2012 to do with safety, health and welfare at work. And it's Regulation 28G of that, in the first place, requires an employer to take the working posture and position of employees into account while they're using work equipment. So, I mean, that's quite vague again. He only has to take it into account according to that particular provision. But what that does mean is that he needs to consider it, he needs to look it over, and then he needs to consider the hazards and how best to avoid those, which of course is where yourselves will come in. However, it's Regulation 69 that really contains the meat of that, because that goes into a reasonable measure of detail in terms of the duties of an employer and how those apply to manual handling of loads. So there's four main duties there. The first one is the duty to take appropriate organisational measures or use appropriate means, in particular mechanical equipment, to avoid the need for manual handling of loads by employees. And as a lawyer, what strikes me there is that usually statutory provisions have something like, he needs to take all reasonable precautions, or apply reasonable provisions, take reasonable steps, blah, blah, blah. This doesn't mention reasonable at all. It says appropriate organisational measures or use appropriate means. So basically, the employer is under a duty to take all appropriate measures, even if they go further than what should reasonably be required, in order to avoid the need for manual handling of loads by employees. And the next duty says where the need for manual handling of loads by employees cannot be avoided. So not where it's reasonably impracticable, not where it would require an unreasonable amount of effort, but where the need for manual handling of loads by employees cannot be avoided, at all, where the employer has basically moved heaven and earth, and it still cannot be avoided. Then the employer will be under duty to take, again, that word, appropriate organisational measures, even if they go further than what's reasonable. Use appropriate means or provide employees with such means in order to reduce the risks involved. So we see already it's quite a heavy onus on the employer. It's not a duty of reasonable care at all. It's a duty to do as much as is in his power to do to avoid manual handling, or failing that, to reduce the risks involved. Similarly then, the third duty goes into a bit more detail. So where the need for manual handling, again, cannot be avoided, the employer has a duty to organise workstations in such a way, first of all, as to make such handling as safe and healthy as possible. So not as reasonably possible or reasonably practicable, but as safe and healthy as possible, essentially regardless of cost, regardless of difficulty, is how the legislation has to be read in that regard. And on top of that, there's a few extra obligations under that provision. The employer has to assess health and safety conditions of the type of work involved and to take appropriate measures to avoid or reduce the risk to employees, particularly of back injury. He needs to ensure that particularly sensitive risk groups of employees, so that can mean employees with physical disabilities, perhaps employees with learning disabilities, if the employer employs them, if they're having difficulty following instructions or otherwise, or employees who are in particularly dangerous, risky or sensitive lines of work. Those employees need to be protected against any dangers which specifically affect them in relation to manual handling of loads and the individual risk factors. And I'll come in a second to what those individual risk factors are. The employer needs to ensure that where tasks are entrusted to an employee, his or her capabilities in relation to safety and health are taken into account. So that's again the employee's own subjective capabilities need to be taken into account by the employer. He can't just say, well, what would a reasonable employee or what would an average employee need in this area? He needs to tailor it specifically to, John Murphy is the employee working in this area. He has these particular capabilities. So how do I tailor the safety and health requirements to those capabilities and to his requirements? And the employer also, when carrying out health surveillance in relation to manual handling of loads, needs to take account again of the appropriate risk factors. And finally, the employer has a duty to ensure that those employees who are involved in manual handling of loads receive general indications and, again, where possible, even where that goes further than what should be reasonable. Where possible, the employees should receive precise information on the weight of each load and on the centre of gravity of the heaviest side when a package is eccentrically loaded. So I'm not familiar with that term or phrase myself, eccentrically loaded. I assume means where there's some sort of an imbalance in the package or instability. So those employees need to be given, where possible, precise information on the weight and the centre of gravity of the heaviest side, or otherwise general indications of that. So the risk factors that have to be taken into account specifically include the characteristics of the load. So, the weight of it, the measure of it, the shape of it, the distribution of the weight, the centre of gravity therein. Sorry, I'll just see if I've covered all points on that. Yeah, whether it's unwieldy or difficult to grasp, whether it's positioned in a manner requiring it to be held or manipulated at a distance from the trunk, or only with a bending or twisting of the trunk, and whether it's likely because of its contours or its consistency to result in injury to employees, particularly in the event of collision. So those all need to be borne in mind in terms of the load itself. The physical effort required, the employer must consider if the physical effort required to manually handle that particular load would be too strenuous. Could it only be achieved by a twisting movement of the trunk? Would it be likely to result in sudden movement of the trunk? Or can it only be made with the body in unstable posture? The characteristics of the working environment have to be borne in mind. So obviously they can increase risk if there's not enough room, particularly vertically, to carry out the activity, if the floor is uneven or slippery, if the place of work prevents the handling loads at a safe height with good posture, if there are variations in the level of the floor or the working surface that require the load to be manipulated on different levels, if the floor footrest is unstable, or if the temperature, humidity or ventilation is unsuitable. So again, the employer has to consider all of those factors in mind and has to take all appropriate steps to minimise the impact of that. The activity itself, of course, may present a risk if it entails over-frequent or over-prolonged physical effort, particularly spinal effort, if it involves insufficient bodily rest or recovery, if it involves excessive lifting, lowering or carrying distances, or if it involves a rate of work imposed by a process which cannot be altered by the employee. And then the final one is one that Sheena referred to, again, in her presentation. She said it's present in the English regulations. She wasn't sure if we had an equivalent form, but it's the individual risk factors of the employee. So the employer needs to consider that the employee may be at risk if he or she is physically unsuited to carry out the task in question. So again, that's the subjective capabilities of the employee. Obviously their own particular strength, abilities, whether or not they're physically disabled. They may be at risk if they're wearing unsuitable clothing, footwear, or other personal effects. So the employer has to bear that in mind. He has to ensure that they're appropriately dressed for the task at hand. And if the employee does not have adequate or appropriate knowledge or training in that area. So of course the employer cannot simply take it for granted that the employee knows what's involved, that they're fully trained or fully knowledgeable about it. He has to inquire into it, and if there are gaps in the employee's necessary knowledge, he has to take appropriate steps to fill those gaps. So that's just a quick look over the regulations. Now, there's one particular point I think that Marek specifically asked me to advise on, and that's the potential liability of health and safety instructors in the event that incorrect information or out-of-date information is given to employers and employees at training seminars. So it should be borne in mind that in any case where you do agree to give such training, obviously, well, presumably that'll be pursuant to contract. You or your company will be paid for that information. And unless the contract specifically states otherwise, be it a written or an oral contract, unless specifically states otherwise, the courts will imply into the contract points such as the instructor will have the requisite skill, experience, qualifications, training and expertise to give the course. So obviously, it can't just be someone like me who would have next to no knowledge of ergonomics and manual handling. It needs to be someone with the relevant credentials and qualifications. You need to be in a position to give the course out of your own knowledge. The instructor will be assumed to be sufficiently acquainted with the legal and technical aspects governing that particular area. So again, you can have all the qualifications in the world, but if you don't know anything about that specific area, then you may be at risk. The training given by the instructor, of course, will have to be accurate. The information will have to be current and cover all reasonable updates to the area. I mean, Sheena mentioned again in her presentation that some of the information she'd give in terms of training, a decade or two ago would no longer be appropriate. And so you need to take reasonable steps to make sure that the information you're giving is accurate and up to date. The training given should be sufficiently comprehensive in itself to meet the needs of the employee. So in other words, the training needs to be such that if those employees follow the training you give them fully in the workplace, that should be enough to minimize the risk of injury. Like, you shouldn't just assume without good cause that they're already familiar with certain areas or certain points. And if the worst happens later on and you're asked about that, you can't just say, oh well, I assumed they knew about it. I mean, I wasn't asked specifically to mention that, so I didn't. Now obviously that will act as defence in terms of major areas. I mean, again, manual handling and ergonomics are more or less self-contained. You wouldn't be expected to advise outside of those, but you would be expected to give comprehensive advice on the relevant topic within those areas. So don't make assumptions, of course, that the employees will already have familiarity with the area, because that can rebound on you unless you're given specific information to the contrary. And of course, the instructor will be required to deliver that information in a reasonably clear manner, such that a reasonable employee attending the course will be able to understand what you're saying without the need for further specialist training. So again, unless you're specifically told otherwise, you'll have to tailor the information you're giving to the audience. And you'll have to make sure that the information you're giving them is essentially self-contained, if you like, and that will in and of itself be enough to minimize the risks involved. And so those are all contractual requirements. You'll also generally, I think, be required to take reasonable care to ensure that those criteria are fulfilled. So unlike the employer, as we saw, you don't have to take all possible care. You just have to go as far as is reasonable, unless the contract specifically says that you have to go further. So there are two, if everything goes wrong, and if everything goes wrong because of the training, the information you've provided, we have to consider two sides to that. First of all, will the employee who is injured as a result be able to recover as against the instructor? And second, would the employer be able to recover? So, well, obviously, if any information that you give is incorrect anyway, even if no injury is caused thereafter, that is a technical breach of contract, and the employer is technically entitled to recover, damages from you, which would only really be your fee for the talk. But in and of itself, I don't think that need concern us. However, if the staff follow that advice that you give them, and it was, insufficient or incorrect or out of date, and if an employee suffers an injury as a result, in my opinion, the employee will be entitled to sue the instructor directly for negligence, provided it was reasonably foreseeable that the incorrect advice could result in injury. So obviously there might be some incorrect advice you give that, wouldn't be expected to cause injury except in extreme cases. I wouldn't worry about that. The employee wouldn't be entitled to recover in those situations. But if you give incorrect advice, whereby had you stopped and thought about it, you should have considered, well, actually, this advice, if followed, would be likely to cause an injury, then you will be liable, in my opinion, to the employee. There's two brief reasons for that in law. The first is that the fact that you have a contractual relationship with the employer will usually be taken to mean that you owe, what's called in law a duty of care to third parties such as employees who could reasonably be affected by a breach of that contract. So that derives from a case called Wall and Hegarty, where a solicitor's negligence in drafting his client's will meant that the person who was meant to inherit and lost out was entitled to sue the solicitor for loss, even though obviously he didn't have a contract with the solicitor. So equally, even though you don't have a contract with the employee, the fact that you have a contract with the employer will, in my opinion, be enough to show that you have to take reasonable care to protect the employee's interests, if that makes sense. And the second reason in law is because a person, such as in this case an employee, who relies on statements made by another person, such as an instructor, who possesses a special skill, and where the employee trusts that instructor to exercise due care, and where the instructor is or should be aware that his skill and judgment are being relied on by the employee. In a case like that, if the information given is negligent and inaccurate, and if injury is caused as a result, then the employee will have a cause of action against the instructor for his loss. So again, that's just another point in law, something called negligent misstatement, which is whereby if you say something to another person, in brief, even if you don't have a contract with that person, and if you're in, it governs lawyers giving advice equally where there's no contract. If you're aware that your advice was being relied on by the other person and that they knew you had a special skill in that area, then negligence on your part that causes injury will ground a cause of action as against you by the employee. So in my opinion, in such cases you will be liable to the employee. Now the alternative scenario is where an employee, as is generally the case, sues the employer only. It appears the employer will be entitled to be indemnified by the instructor where the employer can show, again, that the injury was caused by negligent training or negligent information given by the instructor. And that comes about as a result of an old rule, a case called Hadley and Baxendale, where a person, in this case such as an instructor who breaches a contract, so you've breached the implied term to give reasonably accurate and up-to-date training and information. So where an instructor who breaches a contract along those lines will be liable to pay damages which can fairly and reasonably be considered as arising naturally from the breach. And I think that would cover employees' injuries as a result of following the negligent training, or on the other hand, damages which may reasonably be supposed to have been in the party's contemplation as the probable result of breach. So I think that would likely cover the same scenario. So where an employer is sued by an employee and the employer can show that it's due to the negligent training or advice provided by an instructor, the employer will be entitled to join the instructor as a third party and to gain indemnity from them in respect of, depending on whether the employer was also negligent, some or all of the damages payable. So that's the bad news. The good news is that from my own research, I haven't been able to find any reported cases where an instructor has in fact been held liable. And in 7 years of practicing law and 5 years before that of studying law, I've never come across such a case myself, certainly as a practitioner. And obviously there have been cases where I have represented employees in those situations. My advice would always be to go after the employer. Now, if the employer can show that the training was negligent, then that might change the situation. But as you might know from your own experience, the overwhelming majority of the time, in these cases, these accidents would happen because either no training was given or in spite of the training that was given. I've never come across a case where an accident happened as a result of bad or negligent training, but just be aware that in law there is no reason why that can't happen. The fact that it hasn't happened yet can't be relied on too far. And just mention briefly as well that the level of reasonable care required will depend on the sort of activity that you're training on. So, I mean, I don't think this applies too much to manual handling and ergonomics. But say if you're advising on an inherently dangerous activity, such as someone who's advising electrical contractors on working with live wires, obviously the risks are huge there. So that instructor would have to take a high level of reasonable care, considering the risks involved, to make sure that the information, the training given, is accurate and is up to date. So manual handling and ergonomics, that wouldn't be seen as being quite as hazardous, because the risks, although of course the risks are severe, they don't normally involve risks of death or paralysis or something like that. But you are still under a duty to take reasonable care, considering all the risks, to ensure that the information you give is accurate and will serve to reduce or minimise those risks. So I'll just briefly speak now on, I'm sure you're all too familiar with them, risk assessments and safety statements in law. So, yourselves, under sections 19 and 20 of the 2005 Act, the employers have to engage in hazard identification and to prepare risk assessments and safety statements. And any instructor or other professional retained to advise in the preparation of those documents, again, you will owe the employer a duty under contract to take reasonable care to ensure the document is accurate, current and comprehensive. And all the other points we covered, such as that you'd have the requisite training, requisite qualifications, that the risk assessment and safety statement would be easily comprehensible to its intended audience, would also apply. It's less clear to whether employees or even members of the public to whom an employer owes a duty of care under Section 12 of the Act, who are subsequently injured as a result of hazards which either negligently weren't identified in the risk assessment safety statement, or which are insufficiently identified, where insufficient steps were recommended that has been minimised. It's less clear as to whether they will be entitled to pursue the instructing professional, I guess, in negligence if the risk assessment or safety statement is negligently drafted. And the reason for that essentially is because, as you know yourselves, when you're giving training, you're there, the employees are there, there's a direct connection between you, there is a direct relation, there is what we call in law proximity between the instructor and the employees. However, if all you're doing is drafting a risk assessment or a safety statement, you may never meet the vast bulk of the employees, and it's not clear whether or not that proximity is present. So again, that point hasn't been canvassed specifically in Irish law. It's what we barristers say an interesting question of law, which usually means someone is going to pay very heavy costs. But under the principle, as we said earlier, in Hadley and Baxendale, you might nevertheless be liable to the employer for a breach of contract in respect of damages paid out as a result of a negligent risk assessment or safety statement. Because if that directly results in injury to an employee, it will be held to flow naturally from the breach of contract. However, there was a case in the High Court a few years ago, Doyle and the ESB, where it's not directly relevant to manual handling, at least not in the commonly understood sense, but the plaintiff was an electrician and he engaged in, I don't know, are you familiar with crimping connectors onto conductors, that squeezing motion? And he'd have to do that around 100 times a day for up to 5 minutes at a time. And perhaps not entirely surprisingly, he developed repetitive strain injury and he sued his employer for damages. And among other points he was seeking to rely on was the fact that the ESB had never prepared risk assessments or safety statements of any type, as it happens. But the High Court found that even though no risk assessment and no safety statement had been prepared, there was no evidence before the court that the preparation of one would have reduced or eliminated the injury to the plaintiff. So essentially, even if a risk assessment or safety statement is defective or negligently drafted, and if either the employee or even the employer is trying to fix the instructing professional with liability, they will have to show evidence showing that the injury would either not have occurred, or would have been less likely to occur if the risk assessment safety statement were not negligently written. And in practice, that will be extremely difficult because, again, in every case that I've seen, injuries are caused by failure to comply with the risk assessment safety statement, or, not infrequently in situations where there were no risk assessment safety statement drawn up. It's never been shown in any case that I've come across that the injury was caused directly by the negligent risk assessment or safety statement. So realistically, even though in law the instructor could be held liable for damage caused by a negligently drafted risk assessment or safety statement, in practice the odds must be seen as being quite remote. So I'll just finish up by briefly referring to, again, I'm sure you're quite familiar, the most recent legislation in this area. So the Safety, Health and Welfare at Work Construction Regulations of 2013. That just touches on manual handling or ergonomics briefly in 2 points. Regulation 37A requires building contractors to ensure that all installations, machinery and equipment, including hand tools, whether power operated or not, used on site, are properly designed and constructed, taking account, again, as far as possible, of the principles of ergonomics. So contractors have to take account of ergonomics as far as possible in ensuring that all machinery, installations and equipment are properly designed and constructed. The other one is Regulation 87.1a, which requires a contractor to ensure that if transport vehicles, including earth-moving machinery and materials handling machinery, are used for construction work, those have to be of good design construction, again, taking ergonomic principles into account as far as possible. So, again, where the legislation says something has to be done as far as possible, it won't be any sort of a defence to say simply that, it would be too expensive to do so, unless it would be at a risk of actually bankrupting the company, or to show that it would be too difficult or too time consuming, again, unless it's something really, really extreme. Because even if it's unreasonable for that particular contractor to take account of ergonomic principles in terms of designing their vehicles and their machinery, they will still be required to do so under law. And so presumably that's an area where, if you haven't already under new regulations, you'll be expected to advise on in the future.